It's good to see everyone.
Yay, Miles.
Well, fantastic. It looks like we've already started recording, so that's great. I just want to make sure I can get, we have a very, very short, incredibly short PowerPoint presentation just to kind of go over a few things. So let me just make sure I can get that on this computer real fast.
Hey, Miles, before you get started, if you wouldn't mind going to the GBA site on the main page and bringing up the link to Government Blockchain Week, that'd be a great thing for folks to know about.
Yeah, absolutely. Here, let me see if I can pull it out. I went to the Future Money Governance and the Law conference last year. It was phenomenal. Fantastic speakers in attendance weren't just, it was a lot of developers, attorneys, but a lot of regulators, a lot of people working for this, for the industry, for the organizations that are really shaping the rules for a lot of the companies that we work with. So it's exciting. I'll tell you what, Gerard, let me find this in a little bit, and I'll send it out to everyone in the chat.
Perfect. One of the folks that is coming, the understanding is somebody from the CFTC, their innovation officer. So that's what you and I talking about this. It's going to be a phenomenal event.
Yeah, no, I'm really looking forward to it. It's always fun being in the Capitol and discussing these exciting changes. Great. We have pretty much everyone here. I don't know if Mike Seelig has joined yet.
Hey, I'm on. This is Mike Seelig.
Oh, hey, great. Sorry, there's quite a few people in the panel, so perfect.
No worries.
In the array that's set up here. Oh, there you are. Yeah. Great. Well, let me just give a brief introduction to this group, and I want to thank everyone for being here. It looks like we have almost 30 people in this on the call today. So thank you everyone for taking some time out of your day to come to the very first legal working group meeting. The legal working group is going to operate slightly differently than a lot of other working groups. We plan to meet once a month, and during that time when we meet, we plan to bring up one legal topic, have a few people speak to it, and then open up for Q&A. So this time, well, we decided to go with DAOs. I know it's an exciting topic, a lot of new things that are happening in the space. GBA itself is also interested in making a DAO. So this is topical for both the organization and for maybe projects you're working on, or maybe you're interested in learning more so you can perhaps work on a project later. But one big thing about this organization is that this is not legal advice. We are not your attorneys, and everything here is going to be used for purely educational purposes. So, but feel free to reach out to all of us at the end or afterwards. We'll include our contact information on the website as well. So feel free to keep the conversation going. Well, a little bit about myself. I'm an attorney. I work for Coach and Law Group, also a contract attorney for Oster McBride. I work primarily with cryptocurrency and blockchain companies in the licensing space. So mostly money transmission licensing, but also KYC, AML, BSA compliance, just a wide range of everything from Bitcoin ATMs to peer-to-peer exchanges to whatever's rolling in. So it's an exciting time. I think this year, next year are going to be huge for new developments. I was actually just talking with some regulators out of Louisiana. The new blockchain bill that they passed, it's going to take a little bit of time, apparently, for them to figure out even how much it would cost to apply for that license. So even though they're rolling new things out, it's going to be a little delayed coming in. But I think that we're going to start seeing this on a state-by-state level a lot more. But I'm going to turn this over to Mike Henson. There's two mics on the call, so we're going to do last names as well to introduce himself. He's the moderator as well.
Well, good morning, afternoon, or evening, everyone, as the case may be. I'm Mike Henson. I'm a partner at the law firm of Perkins Coie, which is an international law firm. We have about 20 offices in the U.S. And throughout China. I'm an intellectual property attorney, electrical engineer is my background, and I do patent prosecution predominantly as well as patent litigation. I'm also the chair of the IP working group for the GBA. It's a pleasure to be involved in this and look forward to our discussion today. Maybe I'll kick it over to Eric and then Mike. for introductions.
Good afternoon, everyone. I'm Eric Guthrie. I am an attorney as well, partner in the Coaching Law Group with Miles. I am the Director of Training for the Government Blockchain Association. You heard Gerard Darche speak. He's a Executive Director. I'm also the author of the book, Blockchain or Die, winner of 2 awards. So I'm very proud about that. It's currently on sale on Amazon, so I'll put the link up in the chat room. And looking forward to doing some very cutting-edge legal blockchain work with some of the panelists and some of you on this call. So this is going to be a great conversation.
My name's Mike Seelig. I'm an attorney in the New York office of Perkins Coie. Since really, I guess, around 2013, I've been doing work in the blockchain space. I was previously at the CFTC working in former chairman Giancarlo's office. And since then, I've been in private practice working on fintech and blockchain regulatory issues, as well as a matter of interesting transactions resolving around blockchain and crypto technology.
Thanks, everyone. So why don't we just kick this off and set the stage here. Miles, why don't you just tell us what a DAO is, and we'll start there, and we'll move on to some different topics that might be of interest to the folks on the call.
Yeah, absolutely. Here, let me share my screen real fast. And so we have a few slides based off of this. And I haven't done this in a use PowerPoint in a minute. Well, you already know who we are. So I think a lot of people in this call already maybe are familiar with decentralized autonomous organizations. Now, the term can be a fairly nebulous concept. There's a lot of different types of DAOs. But generally, and this is a definition I pulled from a paper by Sven Riva. We will have some documents that they'll be forwarded and posted on the site where if you're interested in learning more. Yeah.
Miles, can you just get a little closer to the microphone?
Yeah. Well, it's in my ear, so we'll see how that goes. Yeah. But generally, DAOs or decentralized autonomous organizations are created by or governed by code rather than by a central authority. So you're able to create rules and regulations that are in turn governed by the people that are part of the organization, and that can be a completely decentralized organization where you have people from all around the world, people that you're not affiliated with, that come into the organization and influence it, or it can be more of a centralized system where it's a closed loop organization where it's only people within your company or people within a certain set of companies that influence the outcome. So right here we have just basically it's to deploy autonomous. Oh, people are drawing. I didn't know I could draw on that. That's weird. Yeah, it's running on a distributed system that allows the network participants to work on, most importantly, a transparent basis. So there have been some recent developments in various states. Does everyone see the lines on my screen? That's bizarre. I'm not quite sure.
I see them.
Yes.
Yeah. Sorry about that. I'm not quite sure why those are there. Those are part of the part of the presentation. Yeah.
We really don't like the slides.
Yeah. I guess I'm getting some red marks already, and I promise there won't be a lot of slides. There have been a few states that are taking some initial first steps to define blockchain-based LLCs, and a few states that are making strides to include distributed autonomous organizations, decentralized autonomous organizations as part of their code. So some of the ones we will talk about today is the Vermont blockchain-based LLC. So this is, I believe it came into effect late 2018. Where Vermont has said, okay, if you are interested in having a DAO, we're going to set up a corporate structure that in which you can say, okay, I know who's going to be accessing this DAO. There's a big emphasis on security, emphasis on access and permissions, but it's giving the state of Vermont an idea of how your organization works. And this is incredibly important to understand not just the security of the state, because we're going to talk about this later. I think everyone here might be familiar with the DAO and the ramifications from that, but also, what are the repercussions for if something does go wrong? How do we right these wrongs? How do we protect the people of Vermont? from bad actors. So just going off of Vermont, Delaware is also passing some legislation people might be familiar with on the right, 182, 183. Now this is going to update actually Senate Bill 69 updated the Delaware General Corporation Law, which is a mouthful, but basically just codifying that electronic transactions are legitimate and that companies can use distributed ledgers as official corporate records. This is something that we're also going to see in Arizona House Bill 2417, which did update the Uniform Electronic Transactions Act. There is some talk about the constitutional ramifications of the EU of changing the EUTA, because the EUTA is not just an Arizona issue. This is a multi-state issue, a federal issue. So that's been an interesting discussion that I don't have the right answers for yet. I think we're still working on it. But that's just my general introduction to what's happening right now in the space, and I can turn it over to the rest of the panel.
So thanks for that. I was wondering, you mentioned the Dow and the Dow Report. Mike Seelig, I know you've got some insight that you can share into that. Maybe you could give us a little background as to what that was all about.
Sure. So early on, around I think 2015, the SEC released what's called the Dow Report, and the Dow Report was what would have been an enforcement action. It was settled without any sort of penalty, so it was just released as a report. But what it involved was a decentralized autonomous organization called the Dow, and a number of organizers under a company called Slock.it or Slockit created this organization that was functional based on code that would allow purchasers to go and obtain tokens that are essentially an investment in that institution that would entitle them not only to own a portion of the value of the entity, but also to vote and to actually play a role in governance of that institution. And so this is really the first experiment with a decentralized autonomous organization with respect to governance. You could argue that the idea of selling a token that represents an interest in a company isn't super unique. We've certainly seen a number of these token projects that have issued tokens that might give the owner some sort of interest in the enterprise. And the SEC certainly brought actions alleging that certain tokens do in fact constitute securities. But this was a unique instance in that there was a lot of governance bound up in those tokens. And so when you have the token, you were able to vote on what venture projects the entity would fund. So essentially this was like a venture capital fund that would go about and find blockchain projects or even non-blockchain projects and contribute Ether or other tokens to those projects. And so when you purchase a DAO token, you contribute Ether, it goes into a smart contract that holds that Ether. And the contract will then distribute those tokens based on the voting patterns of the users that hold the DAO tokens. And so that was a very unique project at the time. It got a lot of attention, and then it got a lot more attention after there was a hack of that smart contract. And so when the smart contract was hacked, a ton of Ether was taken out of the smart contract by these hackers. And it kind of caused a bit of a crisis amongst Ether holders as well, because there was this notion that the Ethereum blockchain itself really isn't subject to being attacked based on their beliefs. But these smart contracts and these autonomous organizations that live on the blockchain are vulnerable. There's security holes within those smart contracts. And so what they decided to do was fork the blockchain itself, roll back those transactions to make everyone whole, but it created this blockchain called Ethereum Classic. And so this shows what can really go wrong with a DAO. It can literally destroy a blockchain or to break it into two. And so it's important to focus both on the underlying chain that you're launching an organization on and these security holes, and how to develop your organization such that it doesn't create vulnerability for the entire network, because nobody is successful when the entire chain fails. So the SEC, didn't fine anyone with respect to its Dow report, but it kind of set the groundwork for what became their enforcement playbook for a lot of these token ICO projects, because this was such a novel concept of giving people both ownership and control over the activities of the organization.
So I think it's fair to say that there's a lot of potential legal issues that can come into play when somebody wants to conduct themselves as a DAO. And we don't have a great deal of case law in this area. It's really evolving. But I wonder, and maybe Eric, you can comment on this. How important is it when we're discussing DAO to draw distinctions between truly decentralized organizations that really have no corporate structure to them, or perhaps corporate entities that might want to do some kind of internal governance structure in the spirit of a DAO?
Well, I think it's a great question. I think it's critical because, like this example was given with the DAO incident that happened with the DAO hack. If you start too big and you go too far too fast, you're exposing yourself to a lot of risk. And there's risk all over the place with DAOs right now. The first of it is what you mentioned with the case law. Right now, the legislation is extremely light and there is no case law. So it's kind of wild, wild west. So you don't know what's going to happen when you create your DAO, what may change at the state or federal level once legislation becomes more active and more solidified, in the legislative arenas. So that's number one. You're creating a company in an area that right now is that the structure's not there. The other is you may invest time, money, resources into this. And if your code is not spot on, if you have issues with the way it's been structured, it could be a potential disastrous impact. So the advice I give to my clients is to start small and to create the DAO maybe within your organization and start with small projects or projects that you can manage where your risk is limited. If there's legislation that passes, if there's a problem with the code, you can manage it and then grow it from there. Let it grow organically. But if you start too big, too hard, too soon, your risk exposure is, your portfolio exposure for risk is much greater. You're on mute.
Mike, it looks like you're muted. Yeah.
Yeah, so following up on that, and really for anybody who wants to chime in, Miles, Mike, or Eric, not only do we not have a great depth of case law or anything, or statutes that are to govern these kinds of things, but even if those were to come into play, it's what can go on in a DAO is a bit of a moving target, for example. So if you have something, you might want to deploy a token, and maybe we're not to get into whether something is a utility token or not, but if to the extent the DAO might govern decisions relating to that token, perhaps its status could change, and so you run the risk of those kinds of things. So maybe somebody can talk about the moving aspect of how a company or a DAO might conduct its business and how the legal effects of that might change unbeknownst or in unpredicted ways. Miles, maybe you chat on that.
Sure. I mean, there's a lot to unpack there. There's there's a wide range of issues that could come up. I know one we were talking about earlier is liability. So the idea that if you have a decentralized or autonomous organization, well, let's back that up a little bit further. So if someone wants to create this type of organization, are you creating this organization separately? Or are you creating it within an existing company? And that in itself can raise different legal issues as well. I think one of the things that's really important here is to very clearly state who's in charge of this organization. There has to be an entity. There should be an entity that's standing solidly behind it. I know one thing that we plan to talk about a little bit later is the level of decentralization. So if you are an existing company, this is a way to manage internal decision making. You've limited the audience of the DAO to people that you know and trust. I think that you've in essence kind of limited some areas of liability there. If you are opening this up to a wide range, and it's really not as common, or it's not something that I would maybe consider as common. Maybe other people can chime in on this, to everyone, and where people are able to influence the decisions of your business on a global scale, then there are risks that come from that. And then on top of that, there's questions of are you purposely targeting certain areas, or certain states or certain countries with those activities? So I mean, these are all questions that need to be raised during the design phase.
I think it's important also to distinguish like why you would set up a DAO in the first place, because it seems like an odd concept for an established company to go out and just create a DAO, and there are real use cases for these. Really, they're smart contracts. I mean, they're code. The purpose to really set one of these up is to provide for governance for a protocol. So if you set up a smart contract that's like a decentralized finance protocol that allows for lending or for derivatives contracts or any other sort of finance management software on the blockchain, you might need some sort of way to govern that, and you might want to keep it decentralized because that's the ethos of your software. So rather than have a company that's making decisions about interest rates and how the code will scale and work, you create a token and create a governance structure. And that governance structure becomes valuable because you have stakeholders that are using that software. And so that's where a lot of the value proposition is for these companies that sell that token associated with governance. Folks want that because they want to exercise control over that protocol. And then there's governance decisions that are important decisions that get made by these stakeholders. And so I think both under federal law and especially the securities law, there are a number of issues with respect to creating these organizations that you're divesting a bit of control and power over, but there's typically some sort of developer behind it. They usually don't remain anonymous. There's typically a company that is separate and has kind of made their money through that token sale, and now is going about to build other smart contracts that may be associated with that governance protocol. But it's typically still a fundraise effort and an effort to decentralize that governance function from the central entity itself.
Yeah.
Actually, sorry, I have a question on top of that. I know that part of the governance model, let's say in some of these DeFi system, based on loans, we've seen it with other organizations in the past, sort of the very low interest rate that's grown over time, and although they have mechanisms in place to try to balance that interest rate, are there certain legal issues that companies have to face when they're saying, well, we don't know what these interest rates might be in the future, when there are set guidelines or limits on loan interest rates? Is this something that some companies have to think about ahead of time?
And
Sorry, go ahead.
So the one thing I'll mention, thinking like a regulator, for example, regulators think in terms of, we have this structure, like with the ICOs, it was similar to securities, or with the IRS, it was similar to property, or with commodities, Bitcoin is considered a commodity. So they put these new structures into these boxes by comparison, and use prior legislation or case law to kind of decide where they're going to go from there. The bottom line with the DAO is that, I mean, it's revolutionary in some aspects, especially when it comes to the software running the company. But when you look at a corporation, right, you have your board of directors and you have your shareholders, people that own the stock. And those are two stakeholders that help run the organization. At these shareholders meeting, they vote and make decisions. Well, what's the difference here? The difference is with the DAO, at least two off the top of my head. One, more people can be involved with this because, it's so revolutionary that anyone that owns a token, anyone that's involved in that level can be involved. And two, you don't have to wait for a shareholder meeting. You can have a vote and you can do something pretty much right away. Once you have enough people to, reach the 51%, or to have enough people to make a difference, the DAO now can be changed like it has in the past. And some of them have been in response to some unfortunate hackings and events. So the bottom line is that, this structure is not 100% novel. And when it comes to the legal structure, it has a lot of corporate underpinnings next to it, but it just creates them in a more novel and technologically advanced way.
And as an as an intellectual property attorney, I think it raises some very interesting issues when people want to organize as a decentralized organization, so to speak. You know, when you talk about IP, just to be clear, there's really four things that most people think of. You have patents for the protection of novel and innovative, non-obvious ideas. You have copyrights to protect the expression of things. You think of things as books, paintings, software, of course, especially in this space. Software patents also in this space. Trademarks, things that are things that you use to identify your goods or services to distinguish them from others. And of course, trade secrets, things that business things that might give you a competitive advantage over others. And so it's interesting to me when you talk about a DAO, a purely decentralized organization, to the extent that it has IP, who is the owner of that? Who are the authors or the inventors? If they're truly anonymous, how do you identify those people and those entities? Because if you want to protect IP, you can't file a patent without identifying inventors. You can't file for a copyright without identifying an author or the authors. And if people are truly anonymous, how do you do that? And then what is unlike a corporate structure where it's very common that through employment agreements or otherwise, the employees who invent or create things, those are owned by the hiring party, i.e. the corporation. The corporation can also do work for hire agreements to hire outside consultants, but the IP traditionally flows from the authors or inventors who are employees or contractors to the corporate entity, and then the corporate entity can exploit that IP for a competitive advantage. How does that work in a DAO if you can't identify those parties? I think that's a very interesting thing. How can a DAO contract if it wants to create IP outside of its members? And if I'm on the other side of it, if we're talking about inbound or outbound licensing agreements, and I have some IP that I want to license to a DAO, I'm going to be pretty reluctant if I don't know who I'm dealing with. I'm going to be pretty, probably put a lot of conditions on that, things like that. And what happens if a DAO infringes a third party's intellectual property? As if I'm representing a patent holder and a DAO is infringing intellectual property of my client and I need to go after somebody, who is my target? I would argue, and maybe others with a lot more expertise on this call than me, but I would argue that people are not truly anonymous. And through forensic investigation and the advancement of technology, we could probably identify who some of these participants are even in a truly decentralized manner. And if I'm representing a plaintiff patent holder, for example, I might, because I can't really find who these individuals are, if I can find one of them, I might go under a theory of what's called joint and several liability and see if I can get a verdict or a judgment against one of them that has a deep pocket, and let him or her go figure it out as to who they can maybe go after the other members of the DAO. So it raises some very interesting issues. And so I think it's very important for those considering a DAO and exactly what the objectives are going to be, because you have to really understand these issues, and there can be pros and cons to all of them. I wonder, Miles, maybe if you wouldn't mind putting back up the statute with everyone's red line through it that you put up. I don't know if it's still marked up, so to speak, but Mike and Eric, can you guys maybe go in a little bit more depth and a little bit more context for what's going on in Vermont and Delaware, for example? Maybe we could start with the Vermont blockchain-based limited liability company. I mean, I at the risk of we can share all these materials with folks afterwards, but maybe you guys can just provide a little context and synopsis of what these states are trying to do here.
Yeah, it looks like, so what Vermont's trying to do here, it appears, is create a legal structure for these smart contracts that are out there and allow for, if there's a company that wants to set up its own, and I think it's better to think of these more just, as they say, blockchain-based limited liability companies, because DAOs, it's just such a broad term. They're really just smart contracts that have some sort of governance function. But these are really meant to be creatures of state law, corporate entities or business entities that will have a token or some sort of database that will have an identifier for ownership, which really is likely to be what we consider a token, that will allow for voting rights with respect to the organization. And the law kind of goes about by stating that you can adopt voting procedures, you can use smart contracts, you can propose managers, members, participants of the LLC to upgrade software systems and protocols, et cetera, and make changes to an operating agreement. So really, all sorts of voting with respect to the entity can be done on-chain, on a blockchain. And I think that's really what's novel here. Likely, most of the organizations that go this route will try and set up their own blockchain to have voting on that chain that's closed off from the broader chain, so you don't have issues like forks and failures of the larger Ethereum blockchain. But it's also possible that folks go the route of the DAO and try and set up their own organizations and have their own token that lives on that larger blockchain. But really, and at the end of the day, it's a voting mechanism to make decisions for the organization, and also a way of having ownership of interests in the company. And so it looks like what Vermont really wants to do here is make that all part of its statutes, so we don't have, well, potentially to attract folks to create these new novel entities, because no other state really has this sort of structure, but also to protect its own citizens who are investing in these types of companies, potentially owning tokens in these entities. They have some sort of statute and some sort of understanding of what they're obtaining and what the entity can do and what it can't do. And it's at the end of the day still a creature of that state's law. And so there's organizers, there's an operating agreement, there's all of that, which you typically wouldn't see with a DAO, like the DAO. Or any of these other smart contracts that are out there.
Yeah, so I agree with what Mike said. The point I'll make is, if you look at the, and it's on the slide, if you look at the actual Chapter 25 language on subsection D, it says 2D, adopt protocols to respond to system security breaches or other unauthorized actions that affect the integrity of the blockchain technology utilized by the BBLLC. The interesting thing about that language is that, when I read it, I went back and looked at some other LLC statutes, and there's nothing in there about security or any type of system issues in that language. It's basically just a, hey, you certify with us your LLC, you pay your annual dues. If you have this in the minutes, you do for your meeting, and that's it. The drafters of this statute realized it was so important to include system security as part of the LLC is in the actual language. And in my mind, that's huge, because now it's incumbent upon DAOs to have the actual, as they say properly, protocols, right? To be able to protect the intellectual property, protect the code, protect the system that will keep it from becoming utilized improperly, hacked, or even, make it go bankrupt, which could really impact the company in a very negative way. They put it in there because that is extremely core to what a DAO should be doing, and they put it in the law. So I think that's really important to recognize and for other states to use as an example, because this is going to be something that is the first time it's being done is going to be used as an example for other states when they create theirs.
Miles, do you have anything to add on the Vermont before we move on to Delaware?
This is Heather. May I say something just quickly?
Oh, yeah, sure.
Hi, how is everybody today?
Very good.
Good. So I love the fact that we're talking about this concept, because it really kind of brings into the light that how we need to think about the decentralization nature and the level of decentralization that each company is needing or wanting to accomplish. And one of the best visuals I've ever really latched onto about this is the code is the code is the framework. It is the structure. Every time somebody adds something to the code, which is, or the blockchain, or commits to the blockchain, they are creating that framework. And let's go back a little bit. So if you think about the internet is not patented, correct?
Correct.
Am I incorrect? Okay.
No, you were correct.
The internet is not patented. However, the use of the internet happens every day, every second of every day. And what does happen is people create tools like websites or software that runs on the internet or through the internet. And those are the processes. Those are the structure that needs to be defined so that they do have protocols in place to actually, if their website gets hacked, no one's going, oh my God, the internet got hacked. They're going, so-and-so got hacked. And those particular websites need to have everything in place to make sure that, you know, they are addressing security issues. They do address, you know, what goes on the website. Who gets authority to put that on the website? Who, you know, what sort of forms or linked databases are attached to that website. There's protocols around those. Those are the structures that can really be, well, I'm not a patent person but the intellectual property person, I can't remember who he is, but those are the things that can be patented, those processes, those business processes on how they utilize the internet or the blockchain can be patented. And those are the intellectual property issues that do need to be addressed, because no matter who's using blockchain, I guarantee you everyone's using it for a different reason and a different purpose. Or if you're looking at something like supply chain, a very overarching purpose. And so, you know, if we're talking about patent issues and we're talking about structure and framework and operational agreements, those things can still be done within the organization to address how they work on the blockchain versus, hey, I want to create a blockchain. I need a framework structure around a blockchain, because that's just not going to happen. The blockchain is going to develop as adoption happens. And the adoption is what's going to drive how the framework needs to look. So you can create a website all day long, but if it's crap, no one's going to use it. And so, you know, you want to really make sure that you're focusing on the responsibility of the organization to have internal process to address the legislation, not blockchain legislation, so that we can adopt blockchain process. Did I make that clear? It was really complicated.
No, I think that's a very good point, and
I totally agree.
yeah, and just as a little aside, I coordinate an effort in my firm to actually categorize and analyze blockchain patents. And it might surprise people on this call. It's a very open source community that we have, but it might surprise people that there are currently at least 900 issued US patents in the blockchain space. And that's only in the United States. And there's easily 3 times as that are pending. It's a very daunting thing to try to manage. There's about 10 people at the firm that are trying to keep up with this. But I think it's a very interesting thing to monitor in this space.
I'm sorry. And on an international level, it makes even more sense, because it's almost like if you try to do it from an angle of patenting blockchain or creating legislation around blockchain, it's like creating your own legislation for your own internet. So if all these different countries have their own little internet they're trying to create legislation for, nothing's going to work together. It doesn't make the network more robust. It actually breaks it down and makes it more vulnerable.
So Miles, did you have anything to add on the Vermont before we transition to Delaware?
Yeah, sorry, I was I was actually pulling up some notes on the money transmission licensing requirements for Vermont. And I wanted to add to Eric's point on security. And now some states do require security audits for companies that are applying for money transmission licenses. It doesn't look like that it's required in Vermont. So it's interesting to see that BDLCs are required to have these security audits made before they can register, while money transmission licensing companies don't. So I think that it's a good step to have. But I'm ready to move on to the other. We have a couple other states that are on. By the way, this is not an exhaustive list. There's other states like Nevada and Illinois that have also passed legislation on this. So I encourage people to do some research and look into some of the other states that are working on this. But I'll move over to Delaware.
So can I ask you a quick question real fast, Miles, just for clarification?
Sure.
Were you saying that in the Vermont that they do allow money transmission DAOs? Is that what you were kind of saying?
No, so what I'm saying is that there's a separate licensing process for money transmitters. I don't see any reason why a DAO couldn't be licensed as a money transmitter in the state of Vermont. I was more making the point that the licensing requirements for money transmission do not require a security audit, while a security audit is required for the blockchain-based LLC in Vermont. And I do believe that these security audits are really going to be an essential part of all state legislation that we're seeing. We saw something coming out of Louisiana. There's a gradual move to have the states regulate cryptocurrency companies, and a lot of what we're talking about here is going to be cryptocurrency companies to have their own rules and procedures.
Thank you.
So Mike, could we transition to Delaware? Maybe you shed some light on what's going on there.
Yeah, this is also dovetails a bit with the UED stuff that Miles had showed earlier on the screen. A lot of states are looking at their statutes around electronic transactions, contracts, and corporate documentation, and saying, well, like, we have these smart contracts and blockchains, and a lot of things are happening in a more automated fashion, and they're being electronically signed, but not in the way that we typically electronically sign through DocuSign. And so that might change the way that the enforceability of certain laws that with respect to the kind of analog methods, even though some of this stuff is meant to bring us into a digital age, blockchain is just frankly different from some of the electronic technologies we have. And so this Senate Bill 69 and Senate Bill 182, 183 revised the LLC Act to allow for electronic databases like blockchains to maintain corporate records and to allow for certain electronic transmissions. It's not necessarily the case that that blockchains couldn't be seen as an acceptable method to maintain certain electronic records. There may be arguments that they need to be backed up in a different fashion and not just maintained on a blockchain due to vulnerability. But really what they're doing here is just recognizing that this is an acceptable means to maintain documents and to maintain records of ownership. So if you're a shareholder, that might be reflected on a blockchain. And we haven't, we've seen some companies working on this type of technology, but it's not mainstream. We still, rely upon, other methods to maintain ownership, typically with more of a register system. But it's good to see that the state has acknowledged this as a legitimate way to maintain ownership and to kind of allow for liquidity, because some of these private companies, issue shares and there's really no easy way to transfer them. So a blockchain really does create through tokens a very liquid means to move assets, and that certainly raises securities law issues, et cetera. But it's good to see Delaware kind of adopting this and being a first mover, as Delaware is the state where most companies go to incorporate.
And do you anticipate that other states will follow suit?
I think it's possible. I mean, I think that this is an experiment and an interesting move. I don't think there's anything really preventing corporations necessarily from incorporating using blockchains and to record these sorts of things. I think you have to look at each statute on a case-by-case basis. But other states that want to attract blockchain companies might get on this, the same bandwagon and kind of say, for the avoidance of doubt, you can always use a blockchain to maintain this. And it'll be interesting to see whether companies move in that direction across the board.
And to that, I want to just briefly clarify what I was saying before. This is not similar to the Louisiana law that we've seen come out recently that regulates all cryptocurrency companies, but it is something that's published by a state that does legitimize some use of blockchain technology. But just I'm going to butcher this this case briefing, and I don't remember the case name, but years ago, Delaware had, and by the way, the person who decides this case in Delaware is the vice chancellor, which is probably one of the best job titles that I can think of. But the vice chancellor of the Delaware court that was looking over this was dealing with a case where a company was being sold, but in that period of time within that sale, there was a lot of stock distributions. And it became incredibly messy to figure out, to really determine actual ownership of the company. And the vice chancellor wrote, you don't see this very often, he wrote, it was a Herculean task to figure this out. And it was practically impossible to really determine complete ownership of the company by the time of the sale actually being completed. So one application here, and one of the reasons I think Delaware is really in charge here, is that this would eliminate a lot of that manual labor that goes into figuring out corporate ownership when there's a flurry of transactions, especially leading up to a sale.
I have a question. This is Heather. Is there a difference in law? I'm sorry, I just haven't looked at this. But is there a difference in law for private investment versus institutional investment?
Before getting that, I think somebody might need to mute themselves. If the speakers can stay unmuted if they want, but perhaps if others could mute themselves. I hear some background noise. Sorry, Heather, I didn't.
Oh, I'm sorry, I can talk louder. Is there a law that specifically addresses private investment versus institutional investment? And if so, how is that different from, say, angel investors versus JP Morgan?
Really, there's no specific law that distinguishes between an institutional investor coming in and a non-institutional, but there are laws around accredited investor status. And actually, there were some changes finalized today to the SEC's accredited investor rule. But typically the way it works is if you're an accredited investor, which there are certain thresholds that you can qualify, certain income thresholds, as well as other. Now there's an educated kind of status threshold where you're a sophisticated investor by virtue of having passed certain coursework or taken exams. You're able to invest in private companies, and you're able to for example, like a lot of these token sales with SAFT agreements, which were kind of pre-sale agreements, you're able to invest only if you're an accredited investor in the United States, and that's all under the SEC's kind of regulations and Reg D investments, as well as there's also Reg A, which allows for certain non-accredited investors to invest. But really, an institutional investor would always be qualified as an accredited investor, and so that's really the main distinction that you'd be seeing there.
Okay, are accredited investors held to a different level even if they invest in a private scenario?
So the real different standard is that you wouldn't necessarily be able to invest as a non-accredited investor, and so there's certain opportunities that are only available to those accredited investors.
So is this why the legislation is being made, so that accredited investors can invest versus private investors wanting to invest? Like basically, is it just because institutional investors want to be able to have access to it?
Well, that's all under the federal securities laws, and that this wouldn't change anything with respect to that regime, but this would allow for, it would clarify, for the avoidance of doubt, that if you created, for example, a decentralized autonomous organization or some other sort of blockchain-based organization, you'd be able to distribute those shares through a blockchain. You'd be able to keep records through a blockchain, and not just those sorts of shares. I mean, certainly you can envision a consortium or a private blockchain-based network where they have records maintained that are confidential, but they want to kind of have them on their own private blockchain and limit access to reviewing those records to certain folks with tokens, or the right to view that. So there's all sorts of regimes that you can put in place with respect to one of these blockchain organizations that will fit within this framework.
And Mike Seeley brought this up earlier, but what came out today expanded the class of accredited investors. So it did include things like spousal inclusion, as you said before, certificates. If you are determined to be knowledgeable enough to make certain investments, then you're going to be part of that class as well. But there was a whole list of new terms and clarifications that expanded there wasn't any limitation. I don't think there was anything in there that began to limit the accredited investor class. I think it was all expanded, but it came out today and I haven't looked over it as much as you probably have. So yeah.
So Miles, maybe we can switch gears and go over to Arizona here, and then I'd like to just open up to the group for questions after that. Who wants to talk about this? Eric, do you want to chat on this, or whoever? Miles, anybody?
Yeah, it's very similar to what we did in Delaware, what we saw in Delaware. It's basically a law that the House bill basically says that, everything can be recorded on a blockchain, signatures and records. Again, you have to, smart contracts are enforceable, which is a language, again, that was used in Delaware. It talks about blockchain technology means distributed ledger technology. So it does have a lot of the same stuff that, we see in Delaware. I mean, the states that have really stepped up to the plate and really put out some really good first round DAO/blockchain legislation: Delaware, Arizona, Wyoming. I mean, those are the three states that have really kind of, led the way, which, by the way, Wyoming was the first state to put out the LLC, the original LLC law in 1997, which didn't become popular in the US until 1977, and became popular in 1990s. So Wyoming's led the way, even with just general corporate law, making LLCs, the first legal structure in the US. So those are the three states that I look to when I look to legislation when it comes to new corporate structures or how to deal with corporate filings or any type of, corporate liability. When it comes to Arizona, they've done a really good job with this law, I thought. It's very general, but it's not written in such a way that would be limiting or would create issues for anyone that wants to, use a blockchain for any of these kind of corporate recordings or signatures or records. So, kudos to them. I'm looking forward to seeing what they do in subsequent laws in the following years.
Which, and just to go off of that, I think it's Representative Schweikart is the representative from Arizona. Schweikart is a big supporter of blockchain technology. Arizona has also had a financial regulatory sandbox that was released, I think, maybe a year or two ago. So we're seeing a lot of push from politicians like Schweikart. Tom Emmer is out of Minnesota. Darren Soda, Florida. There's a lot of movement in Congress to develop this type of legislation.
And let's not overlook my state of Colorado, please.
Colorado.
We're doing some fun stuff
Colorado,
too.
Yeah, that's true. Colorado has been very good as well.
Yeah. In fact, I think one of the regulators from, I think it was a money transmission regulator. I don't remember exactly, but we had regulators from Colorado out at the last Future Money Governance Law conference.
Yep.
And it's great to talk to them because and it's fantastic to see people get excited about this. that are working in that space. And people are acting. In fact, Louisiana, who we were talking earlier, hopefully we'll have a new GBA member soon. So people are getting interested in this.
Don't forget the bit license in my state of New York, which is the very
Everyone loves
first.
that. Yeah.
Yes.
Thanks for that. Yeah.
So we're almost at the top of the hour. I know we're slotted for 2 if we need that much time, but we thought this would be a good time to just open it up to the floor for questions to any of us, for those that have any. So
Well, there is one question in the
Oh,
chat. How
okay.
do global boundaries affect DAOs? I don't know if you guys see that.
Yeah, that's from Johnny, if I'm pronouncing that right.
Well, I think that there's a lot that can go into this. First thing that came to mind is, some of the FATF, and maybe this is going in the opposite direction. A lot of people want to bring this, but FATF, if you have to register as a virtual asset service provider, are you sharing this information with other vast? If you are, transmitting currency, there's a lot of different international, say, of 5 AML to worry about. You have domestic or U.S. AML, KYC, U.S. regulations, international regulations. You're working in certain countries that have put limitations on this type of technology. What kind of issues may you run into there? China kind of comes to mind on that. So I don't know. There's a lot. To me, there seems like it's a lot to bring up, but it's important to discuss.
So, go ahead, Mike.
Well, certainly just a cross-border nature of the securities laws as well, and enforcing that, both foreign and domestic, as well as other, foreign governments exercising their laws. And if you look at, for example, the European laws with respect to securities, their statute, and ours is a little bit more flexible, where we rely a lot on case law. Their statute's pretty explicit as to what is a security, and it's really what you would think of your typical stock or debt, whereas we have a more flexible idea of this investment contract term, which really means any sort of investment of money in a common enterprise with a reasonable expectation of profits, where there's entrepreneurial efforts of others. And that concept doesn't exist in most other countries. And so a lot of these things that we think about here as securities or the corporate shares may be just kind of widgets in these other countries. They're just tokens. And so that's important as well when you're considering these tokens flowing across borders, where in the United States, they're considered equity or securities, and in other countries, it's more like Bitcoin or Ether. It's more of a virtual currency. And as Miles was pointing out, that there's virtual currency laws with respect to money transmission. As the FATF's put up guidance on that point, and a lot of states or countries have adopted those policies in their legislation and regulations.
Yeah, and Mike set it up perfectly for what I'm about to say. In a lot of countries, the ability to invest in the stocks or to invest overseas is quite limited. And even in some countries, women can't even own bank accounts or can't invest in, make any investments without being on their husbands or their fathers or their cousins or their uncles' account. But now with a token, like Mike was saying, that's not recognized as a bank account or investment or fiat currency. So now you have people that can invest globally using the tokenization of software and the DAOs, where they couldn't do it before. So it does open up actually the investment possibilities and creating company possibilities that for some parts of the population globally didn't hurt to exist.
50% of the population.
There you go.
So we've got a question here from Max Gravitt, and he's asking, what is the benefit of registering smart contracts with the states? Is it limited to people, companies that want to raise capital? Who wants to take that one?
I'm going to tee it up and ask Eric, because I know he's in the does government contract work before, but would this influence, let's say some situation where you have a company that wants to have a government contract. I mean, it seems like they would have to have this type of company registered and set up in order to achieve it.
Yeah,
But I
so,
could be
so
wrong.
that, yeah, that's definitely one benefit. I mean, if you want to be recognized as a legitimate, experienced company that has smart contract or blockchain experience, registering can definitely, you know, work well for you in terms of putting it on your capability statement, you know, or if you're responding to RFPs, or if you're looking at, you know, the government websites for contracts, that could be very helpful. That's number one. Number two, I mean, some of the more unorthodox ways of getting government contracts are going to, you know, well, pre-COVID, going to these conferences and meeting people and having, you know, these speed networking events and saying that you're registered as a company, or your DAO is registered as a company with their state or with the federal government, clearly would be very helpful. It puts you in verified air, because right now there's so few companies that are doing it. Right now, that's the only benefit that I can see. But 10 years from now, to say you've been doing it for 10 years versus a company that's starting just, you know, like yesterday or the day before, you know, it gives you a track record that they don't have, which gives you the leg up on those government contracts.
In the US.
Well, yeah, but so not only in the US, right? So if you have companies like in the UK, and they have similar types of, you know, systems to register your company or to, you know, create a blockchain LLC, you know, it can happen in whatever country where that system exists. So I don't want you to think that this is just a US thing. I mean, this could be multinational, right? We're not there yet, but we can be there yet. And the companies that think that far ahead and use this system to their advantage can be, you know, the leading edge of this whole nationalization of blockchain registration. It's not the blockchain itself, because it's already, you know, a global phenomenon, but to follow the laws for each country, you know, that could be very helpful for your business.
But there is such a thing as ecosystems and reputation networks and trust networks that can be built along the way. And those, like you said, who are doing this early in the experimental phase, start to build those networks, like it or not. Even if failure is called a success in the blockchain community, because we learn lessons from those. And also, I just want to touch on the fact that you talked about government contracts. Those government contracts have supply chains, and those supply chains can utilize blockchain to track shipments, figure out predictive analysis on future shipments, be able to identify what's sitting in storage, what's not, what's actually in transit, what needs to be dealt with now versus what needs to be dealt with later, and also an initiation of smart contracts down the line that completely remedy the holdup situations. So if you're talking about government contracts, what you're really talking about is government or global supply chains for government. And if the supply chains are able to actually utilize the blockchain, the governments are willing to accept the data behind that, because there's less risk involved for them. And if there's less risk involved, then that means they're going to waste less money, and they like that. There's less risk of actually losing your shipment, or having somebody confiscated. I know there's a lot of corruption issues out there that we haven't talked about. You know, we talk about protecting the investors, but we don't really talk about the risks that blockchain can eliminate. We don't talk about the fact that money can flow in because it's actually tracked and traced without the equivalent of a double spend, saying, hey, it's here, it's supposed to be here, but it's not here. We can't I'm sorry, I lost my train of thought on that. But
Well, let me just
But-
start to say this, that it's true that that global, that blockchains and supply chains are very beneficial for the use of the government. In my mind, I mean, that's probably one of the greatest benefits that can be gleaned from blockchains in terms of governments. However, it's far more than that. There's government contracts out there for security, for blockchain security for government systems that are right now being tested. There's blockchain solutions for identity, processing and identifying people, whether it's, from this country or from different countries. So it's far more than just supply chain. And I think that we'll begin to see more blockchain use cases for government as time goes on. There's voting, in West Virginia, they did their first blockchain voting 2 years ago when they during the midterm election, and the folks that were overseas, the expats, the military, they use blockchains to vote. So yeah, I want people on this call to think beyond supply chain. I want you to think about any system that could benefit the government and the voters and the taxpayers. That's where the true magic of the blockchain lies.
So Johnny is asking, does it mean that the Dow should or must be on a private blockchain in order to restrict use from unauthorized individuals or companies? Presumably, to the extent it's on a public blockchain, somebody could fork it or copy the code and integrate it into as their own DAO, I guess, is what she's driving at here. Which seems to me, if you really wanted to avoid that and protect against it, putting it on a private blockchain that's permissioned would seem to be the way to go.
Yeah, I agree with that. I mean, I think really the rationale for a lot of these permission chains that are being developed, and some of them are private, some still allow public access in terms of viewership. The purpose is to limit who's tampering with the chain, who has access rights, who has the right to kind of make transactions on that chain. And so some of these are very well situated to allow companies to experiment and issue their own shares on those chains, versus if you look at some of the projects out there like Polychain with respect to, or Polymath rather, with respect to issuing tokens on the Ethereum blockchain. There are a lot of issues, and you haven't seen a ton of gravity to the Ethereum blockchain, just because there's kind of that Ethereum blockchain risk that you're taking on by tying your shares to that blockchain. And companies are experimenting with it, and they do have their own smart contracts, and some of them are using side chains and all sorts of ways to minimize the risk with respect to the Ethereum blockchain that they're taking on. But I think that a lot of these companies are going to gravitate towards, in the near future, towards private chains, and eventually some of these private chains will probably be big public infrastructure blockchains that folks are going to use, but there's going to be side chains and kind of permissioned access with respect to some of this stuff. But a lot of them are, we saw the other day Ethereum the Ethereum Foundation acquired Quorum, which was JP Morgan's blockchain development shop. And there's the Enterprise Ethereum Alliance, and there's a lot of gravity around this Ethereum network. But it remains to be seen whether a JP Morgan's going to go build a business or issue shares on the Ethereum blockchain. It seems more to be the case that other networks and as Mike mentioned, a lot of these hold their own IP as well. So like they're not releasing all their code open source, so folks can play with it and potentially expose vulnerabilities. So like the Hedera network, for example, like that's a private, even though it's a public chain, they hold their own IP. It's not an open source chain. And so there's kind of all sorts of varieties with respect to chains. And I think you're going to see gravity towards those lesser public, less open source chains when you're issuing your own securities on that chain.
So Tanisha Scottman asks, as a person developing code that I want designed to be regulatory friendly, does anyone have thoughts about the divide between value and ownership? Meaning, can ownership become more of overarching value? if I understand that correctly, I think what that's driving at is, as the developer of the code, depending on the context, you may or may not be the owner of the code, but ownership of the IP will give you control over how you exploit that IP. So you can do it, you can license out the IP either exclusively or non-exclusively under different fields of use. You can choose not to enforce it against anybody or grant everybody basically a royalty-free license if you're feeling very philanthropic. So ownership is control in essence.
Or was that a question also on in terms of ownership based on token ownership? Like, for example, if I own more of the governance token, I have more ownership within the company, because that's a whole, you know, that's a whole nother issue on top of that as well. But yeah.
So when it comes to being regulatory friendly, I'm going to go back to law school 101 here for a second, right? Primarily speaking, law is created to do one thing: protect property, right? Whether it's personal property, whether it's your person for criminal law, your estate for family law, whether it's your intellectual property for intellectual property law, right? So if you want something to be regulatory friendly, you want to create code that is going to either protect someone's rights or not infringe someone's rights. That's the first thing, right? And the second thing is they have to be able to understand what you're doing and to be able to make it such that it's user friendly, or, you know, it's not going to be confusing or seen as something that's going to be like with its ICOs, you know, with false statements and misleading. Not all of them, but some of them. If you read some SEC reports, you'll see which ones I'm talking about. And those are the ones they found that were, you know, a violation of SEC law. So if you want to be regulatory friendly, just, you know, protect property, make sure the individual is understanding of what you're trying to do, and you're very transparent with what you're writing in your code and how it can affect them. And I think if you hit all those marks, you'll be fine.
Yeah, and we've talked a lot about existing regulation. I mean, this isn't a there's new technology, but it's not a whole new area of law. I mean, this is kind of built off the back of giants, from everything from, you know, securities laws to your corporate law to everything. We've touched on a lot of different subjects, and even I've seen privacy talked about in the chat. So there's a lot that can go into it. One of the things I was thinking about bringing up very early is this article we talked about before within this panel, the idea of you're not reinventing the law. You know, there's an article called Law of the Horse, which is kind of a seminal article written for cyber law in the 90s, and that was really taking off. You know, there's a lot of existing rules and regulations, just like what Eric mentioned. You have to kind of you have to really go to the basic levels of, you know, why does a company exist? What kind of compliance mechanisms already exist for these companies, and then structuring your blockchain-based company to follow those rules.
Here's a great one from John Carpenter. If a DAO violates GDPR or California privacy law, which I assume he's referring to the CCPA, how would you expect that to be handled in the real world? I'll defer to one of you guys on this, but I would certainly expect that we would caution clients to be very careful about what roles the peers or the nodes on the blockchain are having based on their location, so that they can best protect against probably the eventualities of violating GDPR and people's right to be forgotten. But who wants to take this one?
I'll jump in a little bit on that, because there's some really interesting work on controller and processor relationships, and also joint controller relationships. So when you're in the design phase and you are figuring out how this is actually going to work, it's important to understand what who's actually making decisions, who's carrying out those decisions. Because under GDPR especially, there are specific requirements if you're a processor versus a controller, or versus if you're a joint controller. So there's, if we're talking about a scenario in which something bad has already happened, a breach, a bunch of PHI, for example, has been leaked, I think it's going to be treated exactly like the same as any other data breach right now. But the real danger to me is how do you set up your own internal corporate governance to either one, prevent that from happening, which is really the trick, or two, how do you react to it? Do you have breach notification standards put in place? Do you have is there a privacy? And there probably isn't a privacy officer. And if you're a company operating under GDPR, you probably need to have a privacy officer. Same thing with CCPA. CCPA also introduces a whole bunch of other rules, like you have to have a call-in line, toll-free line to call in. That's probably not going to happen with this. So yeah, there's a whole host of privacy issues that are raised, and this is kind of going back to one of the issues we talked about before. If you're an established organization, like if you're Consensus or if you're Ethereum or JP Morgan, you have those procedures in place already, and you're building this technology under that organization, and so you're going to be already a leg up. And when there is a data breach.
So I'll respond to John's question as well. It's a really good question, and I'm going to start with bridging to my last comment about the privacy law. So if your DAO, if the code in there and the effect of a DAO is actually infringing upon privacy, you may see that as being something that's non-regulatory friendly. That's a good example of something that could be viewed as a DAO or a code that's not going to be in the favor of the average person or the citizen or taxpayer of that state, or federally speaking. But now when you talk about the real world, I'm going to put this in the real legal world. In the real legal world, technology is always light years ahead of the law. Why? Because you can write code or make technology that can change things overnight, just like what the Bitcoin white paper did and the Ethereum white paper did years later, right? What happens with the law, it takes law and legislators years to catch up. Now, they've done a pretty good job this time, right? But the reason why it takes that long is because they have to first get a complaint or see there's a problem. It's got to work through the system. There has to be some type of legal decision on how it operates. It has to be communicated, and it's got to be enforced, as opposed to just writing code, right? So in the real world, you have these new DAOs that are coming out, what they're doing, how they're doing it. The law has to catch up. That's why and we've all said this as panelists, there's no real law right now. This has been going on for years, but it's just beginning to catch up. And that's the real world when it comes to DAOs and the code that makes them what they are.
And this is also something Mike Sue brought up earlier. If we're talking about this is a smart contract infrastructure, rather than thinking about this is a DAO, this is something that exists totally separately. What's nice to see is that there is validity for smart contracts. Like smart contracts are enforceable. So maybe that's a different mindset to have, is that the smart contract legal infrastructure is working well. I mean, it's electronic in terms of electronic information being shared and signed off. And you did bring up DocuSign. I mean, DocuSign has been in existence for quite a while. So, but Eric's right. I mean, we're seeing a lot of new rules and regulations come out that clarify, that expand on it, and I think we're going to continue to see more.
So I'm just skimming through the chats, and some of these don't seem like questions, but conversations amongst people. So I'm trying to figure out. Heather is asking, can we talk about sanctions and working with nefarious entities? Mini DAOs are in China. The equipment that mines for hashing said contracts is made in China.
I have a question for the panel. I don't know if this is ever going to be a real thing, but are there CFIUS concerns? Like, do you have issues with foreign investment when it comes to JP Morgan? JP Morgan runs an organization like this. Turns out a lot of the participants are in China. I would consider that an investment in an American corporation. Beyond that, it's a financial institution. It's a core part of our critical financial infrastructure. I mean, will we run into CFIUS problems?
So you're asking personally, or you're asking from a legal?
Oh no, so no, like is there going to be limitations on
I think there will. I think they will, but again, the law has to catch up. And I mean, the one thing about blockchains and cryptocurrencies, I'm going to just broaden it for a second for cryptocurrencies for this discussion's sake. You know, when specific countries begin to lock down on the use or the transactions or the sale of them, what do these companies do? They just go to a different country. I mean, South Korea years ago, they began to lock down on, you know, these companies making ICOs and cryptocurrencies. So they just said, oh, we'll go to Singapore. And they just went to Singapore and kept their basic operations, you know, pretty seamlessly operational. You know, so you're going to see the governments begin to have to catch up. And it may even require them to work together to cooperate. Because if you can just go from Singapore to South Korea to Singapore to, you know, a Bujumbura or some other country, you know, in Africa or in the Middle East, well, then what good is the regulation going to do, right? So there may have to be some treaties or some other type of international enforcement on this to make sure that, you know, people aren't being ripped off. There's no nefarious actions taking place, and you know, these people aren't engaged in global criminal activities. Not to say that's what happens when you have a DAO, but it's to say that there's always someone to look to take advantage of any technology in a negative way to benefit themselves.
So here's one from Tanisha Scottman. As a lawyer writing code, and I'll just say good for you, because I do the same thing. As a lawyer writing code, my previous question was designing smart contract code that adheres to current laws like GDPR and anticipates new laws. Which way is SEC going to enforce new technologies? So will they ever interpret a DAO token as a security just based on shareholders having governance rights like voting?
So I like to say when you're dealing with the SEC, most of these start off as securities when you're talking about what is it, right? And so then you have to figure out, is there a reason it's not a security? Whether it's Bitcoin or, you know, any other token, and Bitcoin and Ether kind of carved out, but you still have to start with the assumption that it might be a security, because there's always this potentially an expectation of profits. And there's kind of what we call Howie profits and non-Howie profits. Howie profits are really from the enterprise itself, from the promoters, from the folks participating in the DAO in this case. And non-Howie profits are those just based on the market, you know, based on kind of an arbitrage opportunity or some other opportunity that has nothing to do with the enterprise itself. So in a lot of these cases, there's going to be profits based on this enterprise, and so the federal securities laws are going to limit what you can and can't do with these DAOs potentially with respect to tokens. But I think it is important to distinguish a DAO or a smart contract from a business entity, because a lot of these are really just applications that have a governance token. And you can imagine like a video game, you know, a lot of people play like World of Warcraft or something like that, deciding we're going to issue a governance token that calculates whether, you know, everyone gets a sword on Mondays, or, you know, all sorts of things that people could vote on within the game. And so it's broader than an organization with respect to like a corporate entity, and the SEC may not consider that a security if folks are only getting governance with respect to this game, and, you know, people are just trading them for fun, and really any profits just based on kind of the whims of the markets and not based on the enterprise. That's something separate. So it really is a case by case analysis, and you've got to look at it in each case. But the SEC is a basic principle will typically look at these and say it's likely a security because of the profit potential, because of the liquidity. If you look at some of the no action letters that have come out, Pocketful Quarters and Turnkey Jet, both of them are non-transferable tokens for the most part. They transfer into, if anything, a smart contract. So you can't transfer them with your friends. And so they are very concerned about this potential of folks to be trading these on the open market and profiting. So I think we've got a long way to go, potentially not so long, but a good amount of road to go with the SEC before they start looking at these on a case-by-case basis and saying, hey, like the World of Warcraft coin is okay because no one's really trading that as an investment. They're using it for fun, and maybe they make a little bit of money playing around with it. But That's the big kind of road that we have to cross with the SEC before these, I think, really become more mainstream, because I do think the more immediate use for these relates more to governance for software, and some of that is not going to necessarily have a profit component.
So I don't see any more questions in the chat box, but I want to just welcome anybody who has a question to just unmute themselves and ask the group. I'm skimming through here to see if I missed anything, but feel free to unmute yourself and ask a question.
Hi, this is Tanisha. Can you hear me?
Yes.
Okay. I don't care that the SEC does the security, but if this has a potential that everybody wants to decentralize the banks and have a currency for everything that I think is fun. You know, I have a token for just the way that I live that's not been captured in the you know, Wall Street. Then I don't want the SEC to come later and say that they want to try to interpret this value as a profit, because it's not a traditional profit. Any of these that are designed on a whim, if it's a game or if it's you know, betting on a game on the internet, then there is no real value except for maybe entertainment. And now we're in a place where we can see how the value of entertainment and tourism and things like that are completely obliterated. So there may be some interest in, when we have other tech people interested in creating economic markets that more reflect the way that we live, then you don't want the SEC to sort of make up a rule that this is a profit if it's just entertainment. I mean, the entertainment industry has a profit, definitely makes, you know, billions of dollars, but the NFL, all of the leagues make billions of dollars. So there's a profit there, but what is the profit to the individual that aspired to make this software where people could interact with it, say, even when we're in the middle of a pandemic?
Yeah, and I think we're seeing a lot of experimentation around decentralized finance with, you know, if you're an influencer, for example, and you've got receivables coming from based on your promoting of brands on Facebook or Snapchat, and you say, look, I want to issue a token that gives other folks a right to receive profits based on that, you know, like things like that, the SEC may look at more as like, okay, this person's just using a token to monetize his influencer business, versus like the example I cited earlier with kind of like a World of Warcraft type coin, where there's just the aim of the coin is to, it might be tradable, it might be transferable, but the aim is really to participate in this ecosystem and to have some governance rights. And I think that is important with DAOs, because it's not always a profit interest in owning the token. It might just be, I want to influence, let's say it's an environmental company, I want to influence how they're, what projects they're pursuing to help the environment.
Right.
So you can imagine all sorts of use cases, and I think that the SEC will certainly have to entertain those applications and no action requests and look at those, and may offer guidance or carve those out in some fashion. But as it stands now, a lot of the transferability of these tokens creates issues, because there's always this incentive to trade the tokens at a profit. And if the company encourages that, that's where it gets problematic. If it's just the market itself, there's a strong argument that the company is not acting as a common enterprise and creating this reasonable profit expectation based on its own efforts.
Yeah, I think what I was trying to think about is situations where you're trying to avoid a profit, but you're more trying to avoid debt, and that you're doing the way that you live, this sort of decentralized network of a token economy, where you're just using tokens to exist, and that they are sort of incorporated into the way when we're moving from central banks, which is more my goal, is to draft something that doesn't silo in a central bank, but does allow people to access markets in the way that they live for like their utilities. If I want to get a utility coin that uses 50% of clean energy and provides clean jobs where they have fair labor, and those are the types of things that have more value now, but it's not necessarily a profit. You know, I may be able to fund a startup in a way that I wouldn't have been able to fund a startup that's not, you know, one of these big developers, real estate developers say.
Yeah, so if I understand your comment correctly, you're looking for more like a reward token system rather than an investment token system, which, you know, I agree with Mike that, you know, that's clearly going to be an SEC issue.
Yeah, I don't mind the SEC. As a lawyer, I'm not trying to avoid the SEC. I think that's the only mechanism we have to regulate right now, these securities. And it does have some value, but just is not a monetary value. That when people design these decentralized, these DAOs, we're not necessarily thinking about these making gangbuster profits.
No, I wouldn't say
So
that.
once they see that DAOs aren't looking to, like, you know, ERISA forces you to make a profit, but these businesses that are autonomous, they're more value their anonymity, and they more value the sort of overall existence of a business, not just to drive profits, you know, drive your bottom line. ERISA law forces you to make a profit. These businesses, I'm assuming, the ones at least I'm interested in, are being designed in a way that's not just thinking about money. It's not just thinking about the bottom line. So as the SEC develops to try to, you know, regulate and tax and provide rules and guidance, then how are they going to deal with it when people would say they create all these corporations as long as they were not just, you know, make money at all costs, you know, pay people the lowest amount that you can, you know, environment, you know, pollute the environment. That's what most of our corporations can do now because of ERISA laws that forces them to drive the bottom line, you know, to create the bottom line for the investors. These are investors who are more interested in having clean air and having fair wages and having health care. And they're more interested in things that a traditional business is not interested in doing.
Well, I think that's why we're talking about DAOs instead of autonomous or non-autonomous blockchains, because we're trying to figure out how can they securely invest in the blockchain industry without violating their own fiduciary responsibility.
Right.
And in order to do that, they need guidelines to do that.
Right, right.
But we're not interested in that. We just want to pay our people to build, and everyone's trying to put it in a box like they're trying to understand it when we don't have the answers, we don't have the solutions, we don't even have a conducive environment to build and experiment in. And these questions need to be addressed first. How do we pay our
we
people?
can have
How do we get our funding?
sandboxes like they did in Singapore that attracted a lot of interest, where you had, I think they even have them in New York, maybe. The bit license, is that what you did? Where you have sort of a sandbox to play around with new ideas?
A little bit license is kind of the opposite of that, but for example, Hawaii just introduced a sandbox that will allow you to operate without obtaining a money transmitter license and certain other compliance obligations.
And that money transmitter license is always the biggest hurdle, because that's why they want to classify this. They want to understand, does it fall under money transmitting or doesn't? And at what point does it if it doesn't? And I think that's what we can really do to help them, is help them understand when it's appropriate to come in to a project, because that's what they really just want to understand, is when is it appropriate? What kind of laws do we need to properly invest without taking on liability and risk that they don't understand and they can't mitigate
Classify, right.
or classify. Yeah.
Classify, right.
And that's where a lot of the digital asset conversations come in. With digital asset management, if it becomes an asset on the blockchain. So if you have a blockchain, it's just a bunch of money floating around out there. Nobody really owns it. You basically just unlock it and lock it. And that's all you're doing when you're working within these tokenized environments. But they need to know at what point when you unlock it, are we liable, and what laws do we need to make around that?
Right. That's a good explanation.
And so what we as a building community need to do, or even as a country or as a thought process for a global situation, we need to figure out at what point does it become a security and a managed asset? Because that's what they need to know. What we need to do is, what are we allowed to do? Are we allowed to pay our people? Can we get them health coverage? Are we even allowed to take on capital without being arrested? You know, those are the kind of
sort of questions that I was curious about that I had hoped we talk about more. But those are some of the, I guess they're philosophical, conceptual.
Well, it's just two sides of the coin. Like the head's trying to talk about the head and the tail's trying to talk about the tail. And every day we're just flipping the coin going, what are we going to
your turn. Yeah. Don't cut that person off.
So let me just jump in here because I want to get to some other questions. I see one from Jose, and he's asking.
Okay, I'm going to mute myself.
Okay, thank you, Tanisha and Heather. He's asking, how practical do you believe Dow technology can be for corporate governance, state governance, and nonprofit governance? And I guess before I ask one of you to address that, how important is it that we even define what governance is in this context? Because it seems to me that depending on what aspects of governance you might want to Dow for, there might be certain things where it's very conducive to that, other things where you might really want to steer clear. So do we need to really provide a framework for what corporate governance is in order to address some of these questions? Anyone? I see Mike nodding a little bit.
Why does it have to be corporate governance?
And I very much agree with Heather. I really think that we need to start off with the assumption that a lot of these DAOs aren't really corporations or business entities, and they're really set up to govern a protocol. And so then we can think about governance with respect to that protocol. So if I'm deploying a smart contract protocol for lending, there's certain functions with respect to use of that smart contract that I don't want to control. I want to divest to the rest of the community. And that's important to me, both for regulatory purposes, because I don't want to be managing this lending software that could potentially cause scrutiny from the SEC or another regulator, certainly money transmission regulators at the state level. If we divest that to like holders of this governance token, they can make decisions with respect to interest rates and the tenor of a loan and comply with kind of like the retail commodity transaction rule under the CFTC's regulations. So that's a lot of the purpose. And I think that's different from like shareholder activism and what's good for the corporation and making sure that we elect the right board members to maximize profits and shareholder value, which is not, and going back to Tanisha's point as well, like that's not really the ethos of some of these projects and what people want out of their blockchain involvement. And certainly if it's like an environmental mission and the smart contract relates to kind of projects where they get funded, kind of like the DAO, where you're funding environmental projects or you're doing any sort of stewardship for the environment, like that's a different calculus than you would make for a shareholder of a typical corporation.
So I'll respond to Jose's question real quick. I think you're already seeing it. I mean, we showed you Vermont, we showed you Delaware. You know, the states are already beginning to provide corporate governance from a blockchain smart contract perspective. And they're starting small. I think they're starting in manageable ways that they can actually see how often it's used, see how effective it is, if there's any flaws, any problems with their system, and they can grow it from there. So I do think there is a very strong practicality in terms of how DAOs can be used for governance, but as well as, you know, how they're beginning to already incorporate it into their state systems.
And with that,
Those still have to be proven though. Like they're just ideas.
Right, but that's the whole premise of this conversation, because right now the law is not, the DAO technology and DAOs in itself as a corporate structure is just starting out. A lot of this stuff is ideas, you know, so, you know, right now it's going to take some bright minds and people with some really good follow through and some good support at the state and federal level to give this the structure it needs to proceed forward in a very smart and meaningful way, right? So, you know, there's a lot of talk on this call, but, you know, we need to be doing this, we need to be doing that. It's happening. I mean, this call itself is an example of that. You know, we're doing what we can as a blockchain community to make sure that the people that can make decisions make smart ones. And as some of the folks that Miles was talking about when he talked about some different legislators, we have advocates in state and federal positions. We have future money governance in law where state regulators come out and talk to us. You know, and I personally, I've talked to a number of them, some of them in the meetings, some of them afterwards. So, you know, it's not an overnight process. It's going to take time. It's going to take years, and it's going to take good measured progress, because this is really the grand experiment that's starting with Bitcoin and the white paper. This is going to be something that's going to take time to really evolve to become what it needs to be. If we do it smart, if we do it right, it'll be extremely successful, and it will make the world a better place.
It's hard to actually do something right when you don't know what you're doing yet, though, and restrictions limit that. So it feels like in the development industry on blockchain that our hands are tied, that we have to meet expectations that haven't been defined. We have to be afraid to develop and innovate. We don't know how to acquire funding for the projects that we need to develop, which is a huge hurdle. And that was actually limited by regulation. You know, there were all of the tools that we're using now are basically people that ICO'd before it was considered controversial that they couldn't just reverse the ICO. I mean, we're building off tools that are 3 years old now, because it's almost impossible to get anything past the SEC. How do we fix that?
I'd take issue with that. I mean, I think a lot of the projects that have issued tokens recently are some of the more prominent projects, certainly Compound, Maker. You know, not every company chooses to go through the SEC process, or if they do, you know, we don't know the result of their process with the SEC. You know, the Libra project is kind of moving forward in the background, and we don't know what the SEC's views are on that project. So I think that there is certainly an argument to be made in the case of some of these projects that they're not securities, and that's the position they're taking. And companies are taking on a ton of risks taking that position, but that's a position that they have the right to take on.
And I agree with Mike. I think that, you know, a lot of the really recent stuff that's happening, they've actually done their homework, done their Reg A or Reg D filing, and they've complied with the SEC. It's not rocket science. It's, you know, their requirements are very clear in terms of, you know, what you need to do. And companies, pre-DAO, pre-blockchain companies, have been doing this for decades, right? So it's not like it's impossible to do. Everything is there in black and white. If you need an attorney to help you with it, you've got a panel right here, right? So I don't want you to think about this as they're restricting us. I just want you to think about it as there are rules in place that they perceive, which I think has some validity, to protect people from people that are going to try and rip people off or use their, you know, influence to try and take their money in untoward ways. And just know the rules, know the regulations, and just use those to create the product you want. And I mean, you can do it. You just need to put together the right team and have the right expectations.
Easier said than done.
Hey, Miles.
Sure, it is easier said than done. Oh, yeah.
Hey, Miles. Hey, listen, I just want to sort of throw this in because we got about 15 minutes before the top of the hour. And so as you're wrapping things up, I want to make sure you cover two things. One is when you and I talked about the legal working group, I think we talked about a concept where we'd have a public meeting like this periodically where everybody was invited to be part of the discussion. I think these are awesome. And then we're going to have a working group only meeting. And so do you want to, before you wrap up, if you can just let the folks on the call know kind of if they want to engage future, you know, how they would do that.
Yeah.
And then secondly, we have a white paper that I'm trying to finish up today about what we're thinking about from a Dow perspective. And so I'd like to make that available to the legal working group sometime the next day or two. And then you guys can, in your meetings, you can talk about it, whatever. It's not legal advice, but to the degree that your legal working group wants to consider what we're thinking about, then that would be something. But yeah, if you just talk a little bit about sort of the GBA sort of private working group meetings and then the public working group meetings, and then wrap it up any way that you want to.
Sure. Yeah. And first off, I want to thank the panelists for just an awesome panel. You guys, you know, taking the time out of your day, I really appreciate it. I want to thank everyone who's attended. We had practically 40 people here at one point, and it was just a fantastic conversation. Fantastic. The comments on the side were it was a whole other conversation I was following along, and which is great, and it was fantastic questions. So thank you everyone who's been out here. To go a little bit about the governance, to go back to governance of this group, this is the very first meeting that this group has had. And the way that we can see this going forward is maybe around once a month, maybe every other month, we have a meeting just like this. So there's a topic that's chosen, we bring in a mix of attorneys, maybe technologists, or people that can speak to a legal subject matter issue in this industry. Those are going to be rotating. I don't know what next month is going to be. So if people are interested in a particular area, please let me know. And then there's going to be meetings throughout the month, not too often, that will include people within the legal working group. So this is a great example of people in a variety of different communities. I see people in here that are part of a lot of different working groups that I'm a part of. And they're here maybe because they want to learn more about DAOs and they want to learn more about other legal issues going forward. That's great. But I think that there's going to be a lot of people coming in and out. So if there's a topic that interests you, come on in. If there's a topic that isn't really your cup of tea next month, that's okay. You know, but I think that this is going to be a way to reach everyone in this organization and touch on a little bit of everything. And to have a legal working group is like saying we're having a working group that covers technology, right? It's just huge. It's too much. So so this is how we're going to be breaking it down. I don't have a date set up for the next legal working group small meeting, as in a 2-hour meeting like we had today, but we expect to have that out soon.
Yeah, that information will be posted on the GBA global calendar. So if you go under to gbaglobal.org under events, view all events, you can see when we'll be posting those. And then also this session is being recorded and will be available on our YouTube channel. So if you go to YouTube and you search Government Blockchain Association, you'll see a bunch of YouTube videos there from the event we did at the U.S. Capitol last year. Our next major event will be in March of 2021. But we're going to create sort of sub-channels or folders or whatever for each of the working groups. So when we do these public calls, right, those videos will be on the GBA YouTube channel under the legal working group folder. And Jordan will he'll be uploading that, I'm guessing sometime within the next day or so.
Fantastic. Yeah, we're really looking for the next one. I hope to see the panelists out here on different subjects. I know that the panelists here have a vast knowledge of a ton of different areas of law. And this is an exciting time to be a lawyer in this space. This is fun. To kind of go back to one of the comments we were making earlier, I do wish that there were more than 2 no action letters. I know Mike Seeley brought up the 2. He brought, pocketful of quarters and turkey jet. It'd be nice to have more. Maybe that's a selfish thing for me to want. But yeah, I'm really looking forward to keeping this discussion rolling. I know Les wanted to say one thing before we close, but it's got to be pretty quick. unfortunately.
Okay, then I'll be quick. I think it was Heather who said it's easier said than done. That's because it's hard to find people who really know what they're doing. If you look at the Solidity bug list, most of the things are related to concurrency and timing. And we have a ton of people who just got out of programming boot camp and they don't understand either one of those things, and they're going to continue to write really bad smart contracts. So I would suggest that you at least have some focus in this group on not the legal side, because I'm not a lawyer and I don't play one on TV. I'm a computer scientist and a cryptographer. So I see the problem on the other side of this, which is people are writing code that is really, really bad and no law is going to fix it.
Right, and that's why we have security audits requirements. That's, you know, we're seeing that in Delaware. We're seeing that for a lot of different other licensing requirements, and good, it should exist. we need to have some oversight.
So is the goal to get licensing requirements? I'm just curious because that's kind of a new thought process for me.
If you are required to have a license, then your goal should be to go through the licensing process, yeah, to get a license. But thank you so much for everyone's questions. I really appreciate it. I want to thank is Mike, Mike Henson still here, for being a fantastic moderator. Mike Seelig, who's a new member of GBA through Perkins Coie. Really appreciate you being here, and Eric, who I've known for a long time and just a fantastic speaker on the subject always. If the panel has anything to say, kind of closing remarks, you know, now's a great time.
I'll just say thanks. I appreciate the discussion. I thought it was very engaging, and I look forward to a lot of other opportunities to interact in the legal working group and actually do cross-group interactions, because I think there's a lot of synergies that we can exploit. So looking forward to what the future brings for the GBA legal working group.
And I'll echo what Mike said. It was a great conversation. Thank you all for attending. Where your comments were really interesting and very informative. And you know, the space is still developing. It's still happening as we speak. So you know, just stay tuned for changes. And you know, my advice to you is don't be a witness to the change, be part of the change. You know, join GBA, talk to your state legislators, you know, find out what's going on behind the scenes, because if you have the knowledge, you can make this a better product with either in your state or nationally or globally. So, you know, be part of it, be part of the change.
Thanks, Al. It's been fun panel.
Yeah, absolutely. All right. Well, I think we're gonna call it. Thanks everyone for being out here. Look forward to seeing you all the next time we meet, whenever that might be. It looks like it's going to be next month, fourth Wednesday. So look forward to seeing everyone out there, and we'll try to figure out what we're going to be talking about next. But fantastic. Thank you all.